Good afternoon. My name is Susan Lang, and I have the pleasure of welcoming you this afternoon to this webinar and to thank you for taking part in today's program. I'd also like to thank the Law Society for organizing the event that recognizes such an important, evolving societal issue. Recognition of the barriers experienced by many Ontarians in exercising access to our courts is growing rapidly due to the work of many individuals and many groups. Indeed, over 1.7 million Ontarians have a disability, a physical disability, a mental disability, a sensory disability, or a learning disability. Disability is egalitarian. It is not limited by reason of race, gender, religion, or culture. We all know persons with disabilities, and we will all suffer a disability of some kind during the course of our lives. Persons with disabilities are found not with the litigants only in our courtrooms, but in any courtroom or court proceeding, people with disabilities will also be found among the lawyers, the witnesses, the judge, the jurors, the interpreters, or the court staff. Some disabilities may be obvious, such as a person who is using a walker or a wheelchair or perhaps a hearing aid. Other disabilities may be invisible or at least less visible, such as epilepsy, multiple sclerosis, hearing loss, mental illness, and cognitive impairment. Over the next 2 hours, we will identify barriers that persons with disabilities may face in the court. You will be offered practical tips for addressing a wide variety of those barriers. This program is an outgrowth of legislative recognition of people with disabilities. In 2005, the Ontario Legislature unanimously passed the Accessibility for Ontarians with Disabilities Act. This legislation requires Ontario to become fully accessible by 2025. 7 years ago, at the 2005 opening of the courts, Chief Justice Roy McMurtry declared that the courts must do their part to help Ontario reach this goal. Following through on this declaration, Chief Justice McMurtry appointed a joint committee of the bench, the bar, and the Ontario government under the chair of my colleague, Justice Karen Weiler, to develop an action plan on how to make Ontario courts fully accessible. The Joint Committee produced a final report in 2007 that provided a well-needed and often referenced roadmap for an action plan. It is available on the Ontario Court of Appeal website and on the web page of resources in this webinar. I encourage you to read it. The report of the Joint Committee was not left to accumulate dust on a bookshelf in the bowels of Osgoode Hall. Instead, the same year it came out in 2007, Ontario's Attorney General and the Chief Justice of Ontario appointed a permanent committee of the bench, the bar, and the Ontario government to oversee implementation of the recommendations made in the joint report. I have had the privilege since then of co-chairing the committee, the Ontario Courts Accessibility Committee. I first co-chaired it with the Assistant Deputy Attorney General Anne Merritt, and more recently with her successor, Lynn Wagner. They have been terrific partners to work with. Given my imminent retirement from the bench, I have been replaced as co-chair by Justice Janet Simmons of our court, who shares a particular interest in improving accessibility for all Ontarians. And similarly, she also was a former regional senior justice, so also has experience with the importance of providing accommodation. The committee is particularly grateful to the commitment of the bar representatives on the committee, as well as our many committed members from the disability community. The committee has been working on many different fronts. One of those fronts is by producing a regular newsletter. That newsletter, together with other programs, serves to disseminate information to judges, court service officials, lawyers, and members of the community on what each can do to help make Ontario's courts fully accessible. In addition, we continue to discuss matters such as accessible courtrooms and facilities, and to provide suggestions on how to work together to ensure equal access for all to the justice system of Ontario. David Lepofsky has an unparalleled experience in improving accessibility. He has done this for many, many years, and he will be chairing the discussion group this afternoon. For those of you who don't know David, he was called to the Ontario Bar in 1981. He has worked for 30 years with Ontario's Ministry of the Attorney General. Your background materials will give you his biography and the biographies for the other panelists today. But today, David is speaking in his personal capacity, who is someone who has been involved for many years as a volunteer and a very successful advocate for legislative and other reforms to promote equality and accessibility for persons with disabilities. Please give a hand to David Lepofsky for all he has done and his ongoing work in improving accessibility in Ontario. There you go.
Thank you very much.
Thank you.
Good afternoon, everybody out there in TV land. We want to thank the Law Society for organizing this event. Their staff have been fantastic. We want to thank all of you, over 700 lawyers and others from across this province who are tuning in to learn about a subject that hasn't gotten this kind of airplay before, but certainly needs it. And I want to begin by asking you to imagine a day in court. Imagine you're summoned to court to be a witness. You walk in the front door of some busy courthouse, wondering what room you're supposed to go to because you've never been there before. Only they're announcing your name to go to a particular courtroom over a public address system, and you are deaf and cannot hear those announcements, may not even know there is an announcement there to tell you what courtroom to go to. Imagine you're a witness on a witness stand and some well-prepared lawyer stands up cross-examining you and presents you with a document that they wish to grill you on. Only the document is in printed format and you can't read it, either because you're blind and you read Braille, you're low vision and you need large print, or you are dyslexic and you use a speech synthesizer on a computer, also used by blind and low vision people, to read printed materials. Imagine that you are a judge or a justice of the peace, happy to have just been appointed to the bench, showing up for your first day at work, only to find out that to get up there onto the judicial dais, you've got to go up one or more steps. You use a walker or a wheelchair or a scooter. You can't get up that step to go to the very place where you're supposed to do your job. These kind of barriers and many others pervade in our court system in Ontario and elsewhere in Canada and in other countries too. We're going to spend the next 2 hours with you talking about what you as a lawyer can do in court, if you're involved in court proceedings, to assist court participants to overcome, to get around barriers that might impede their access to the court process. We're not just talking about court participants who are parties or witnesses. It could be a witness, it could be a lawyer with a disability, their articling student or law clerk or paralegal with a disability. It could be a member of a family of your client or of a witness who come to court to watch a proceeding with a disability. Could be court staff, could be a judge. We will talk to you about what practical tips there are for you to help us make progress towards the goal of a fully accessible court system. So how are we going to do it? I'm going to speak for the next few minutes about the background of this issue, a bit more about the barriers that are faced, and some of what's underway right now system-wide to try to tackle this. Next, we will hear from two officials from the Ministry of the Attorney General who are directly working on providing over-the-counter customer service help for you, your clients, your witnesses, and others, if any of you have a disability and need accommodations arranged for the court proceeding that you're involved in due to a disability. Next, we will spend a half hour having a dialogue with three widely respected members of our judiciary to give a judge's perspective on what they can do to help and what you can do in the courtroom to facilitate them or to assist them in being able to help remove barriers that might get in the way of court participants with disabilities. And for our final half hour, we will entertain questions from you. A number of those of you watching this program have already emailed in questions. You can continue doing so using the link that's available on your screen. We have an iPad here, which one of our panel members, Justice Stanley Sher, will be reviewing so that he can put questions to all of us in the last half hour. So that's how we're doing it. So let me leap right into my remarks about the background of the situation and what's going on right now. So what's the problem? The problem is this. We live in a society full of barriers that face people with disabilities, whether their disability is a physical disability, like using a wheelchair or a walker or other mobility device to be able to get around, whether their disability is a sensory disability. I myself am totally blind. There are people who have hearing loss or are deaf, low vision people, blind people, other sensory disabilities, whether their disability is a mental, intellectual, cognitive, or mental health disability. Some of those disabilities are invisible. No one knows you got one unless you tell them that you have it. Other disabilities like mine, blindness, is relatively apparent if I walk in a room, if you're sighted and you see my white cane. All of us who have a disability now face barriers every day of our lives. Some of those barriers are physical barriers, like steps to get into a courthouse or a jury box or a judge's dais. Some of the barriers are information barriers, like information provided on flat paper and ink print form, which is very useful if you can't read print due to vision loss or dyslexia. Some barriers are communication barriers, like the lack of sign language interpretation or captioning for important communications. Some barriers are bureaucratic. There's a wide range of different kinds of barriers we face. We face them all over society, not unique to the courts, our schools, workplaces, and so on. To its credit, we've got legislation at the federal and provincial level to tackle these barriers. The Charter of Rights guarantees equality in Section 15 to people with a physical or mental disability. Federal and provincial human rights legislation does the same. And as Justice Lang's introductory remarks explained, in 2005, the Ontario legislature passed a law unparalleled in Canada called the Accessibility for Ontarians with Disabilities Act. It requires Ontario to become fully accessible by 2025 and maps out legislative means for getting us there. What we're talking about here today is the courts doing their particular part to deal with this. Now, why do we have these barriers? It's not like anybody's sitting around scheming, how do we design a court system that folks with disabilities might not be able to use, or let's build a public transit system and make sure that folks with disabilities can't use that. Nobody's out to get anybody. It's usually that nobody thought about it. They just didn't think about it. There's a kind of a vicious cycle that's gone on. For years, folks with disabilities were out of the mainstream, often not seen in the mainstream of life. And then another generation of people grow up writing our laws, designing our buildings, developing public organizations, institutions, and they create a whole new regime of barriers because that just seems to be normal. They just assume people with disabilities won't be taking part in the mainstream. So a generation of barriers keeps people with disabilities out, leads a new generation of people to develop a whole new generation of barriers, and a vicious cycle just keeps going. The simple command of our Charter of Rights, of our human rights laws, and of the Accessibility for Ontarians with Disabilities Act is that vicious cycle has to stop. They set out a goal, fully accessible province. They set out measures that are needed, removing and preventing barriers. Now, I have been involved in doing advocacy on this in a volunteer capacity for many years, but I'm still learning every day. One particular day when I learned a lot, many of you have heard this in a speech I've given previously, please pretend you didn't, as if this were the first time. I was in the Court of Appeal arguing a criminal appeal for the Crown about 15 years ago. My opponent was on his feet arguing his point when he stopped cold mid-sentence. He said, "We need to take an adjournment." The judges agreed, we need to take an adjournment. I didn't have the slightest idea what was going on. I asked my articling student what was going on. and I was told, David, there's been a power blackout. Now, I'm relatively known for, on occasion, being a little tactless. So I leapt to my feet and I said, the Crown is ready to begin its argument. You have to understand, the change in the courtroom had no impact on me. As the judges filed out, they having taken their adjournment, I turned to opposing counsel, who happened to be a friend of mine, and I said, what is it with you sighted people anyway? You expect us to have lights on in every single room you might walk into. Do you have any idea what that costs? Do you know what you're doing for global warming? Half of every day of your life is spent in the dark. I think it's time for you to get used to it. Now, aside from being an illustration of my capacity for tactlessness, this anecdote really reveals two messages. The first is that in any particular morning, people without disabilities don't get up and think, gee, I wonder if I'll be able to get on the bus to go to work today, or I wonder if I'll be able to hear and understand what's being said in court if I have to appear in court, or I wonder if I'll be able to read documents that people will be given to me. They just assume that that's going to go on, that they'll be able to get in, they'll be able to hear what's said and understand it, and they'll be able to read material they're given. People with disabilities don't make that assumption about ourselves and the opportunities we have in a normal day of our lives. Equality would mean that we could, for a first time, make those kind of assumptions. That's the first lesson I learned that day. The second lesson I learned that day I think was equally important. I'd like to share with you. You see, if you were in that courtroom 30 seconds before the lights went out, you might look around, and if you saw me reading my Braille notes, if this is visible on the camera there, you might realize that one of the lawyers in the courtroom had a disability, me. 30 seconds later, there was only one person in that courtroom who could keep working. There was only one person who could argue any point of law, look up any authority, respond to any judicial question, and that was me. That wasn't because God had intervened and suddenly regenerated my optic nerves and given me eyesight again. It wasn't because God intervened and took away anybody else's eyesight, biologically or medically speaking. What had happened is the lights went out. There was a change in our human-created environment. See, most people think disability is largely a biomedical thing, but it's actually largely, or at least the limitations associated with disability, is largely a result of our human-created environment. If we created a barrier-free environment, then everybody could fully participate, and disability would be largely inconsequential in people's lives. So, with that kind of background, what's the deal with the courts? Where are we at, and where are we going? So, Justice Lang in her introduction gave you the heads up on this. Back when the Disability Act was before the legislature, Chief Justice McMurtry, to his real credit, saw that it was important for the courts to do their part in helping make the court system fully accessible. And so he set up the Weiler Committee, which yielded a report, which is a practical action plan, ambitious but practical, on what the problems are and how to fix them. Let me just quickly summarize what the Weiler report says. It's only about 20 pages or so, so it's worth a read. We reached out, I had the privilege of serving on that committee, as among other people did Justice Anne Malloy, who you'll be hearing from later this afternoon. We reached out to the profession and others and did a quick survey about the kind of barriers in the court system. We found out that a number of our courts are old and have physical barriers to access. We found that people with hearing loss have occasion to have difficulty arranging for communication supports they need, that we didn't have a comprehensive system in place to ensure that people with vision loss or dyslexia could get documents in a format they could read. We found that there weren't enough supports in place for people with intellectual or cognitive disabilities or mental health issues to get accommodated so that they could fully participate in the court system as well. So that's what the Weiler report found. So what did it propose? It recognized that we needed a plan. And with our court system, there's no one person in charge who can simply say, okay, you do this, you do that. So it set out a plan that really assigned some responsibilities to the government, some to the judiciary, and some to we in the legal profession, so that each of us could do our part. One of the steps it recommended, and you're going to be hearing more about it in just a couple of minutes, and it's been a really important step forward, was the Weiler report recommended that the government designate a public official in every court facility to be the one-stop shopping place to go if you need a disability accommodation in connection with a court proceeding. Now, some of you may not know this is available, but you're going to hear a lot about it this afternoon. It's a real step forward. So if you go to a court and the current individuals are identified on a web page for the government, and they're available on on the materials for today's program, you will find that there is a person you can go to and make a request for a disability accommodation. Now, they're not going to be able to do everything right away. You're going to hear more about what can be done and how they go about it later. But having a one-stop shopping place to go was a real step forward. The second thing that was recommended is that the government needed to put in place a plan to figure out where the barriers are, both in buildings and in services, and try to fix them. And the government's working on that as we speak. The third thing that was recommended is that judges and lawyers are each in a special position to be able to make changes or to help make changes for individuals. We've seen a real growth in training for judges in this area, more on that in a few minutes, and today is a good example of new efforts to educate lawyers. Overseeing all this, and as an outgrowth of the Weiler report, a permanent committee was set up. You heard Justice Susan Lang talk about it, the Ontario Courts Accessibility Committee, of which almost all of the people speaking today are involved or do work with. And we are working on overseeing the implementation of the Weiler report. It will be really important to get feedback from you in the front lines out there on barriers that you encounter and if there is more that can be done. You'll hear more later on how to contact court accessibility coordinators with specific issues, but you can also get in touch with us through and give feedback through the feedback that is available for this afternoon's program. Because it's only through actual real events going out there on the front lines that we can try to intervene to make things better. One of the things that is also available to you, if you are involved in delivering any continuing professional development in your community on any area of legal practice, criminal, civil, family, estates, whatever it may be, it's worthwhile for you to include a component on what lawyers, paralegals, and others can do to meet the accessibility needs of people with disabilities. And to that end, I'm pleased to tell you that there are some good resources that will help you out. We, at the Courts Accessibility Committee, we were able to get a Law Foundation grant a couple of years ago. We got a couple of law professors from the University of Western Ontario. They pulled together whatever teaching materials they could find around the province in this area, and we've now posted them on a website. It's generously been donated, the web space, by the Ontario Bar Association. The link to these resources are available under the Materials tab for today's program. And so, at least so that you don't have to reinvent the wheel when you want to include something on this topic in a program that you are delivering for lawyers, law students, paralegals, or others, you can take those materials and make use of them. If you develop any new materials, please let us know. That website has an email address that can enable you to forward it to us, or frankly, you can just email it to me. I'm at david.lepofsky@gmail.com, and we can, with your agreement, post that on that website so others who want to do teaching in this area will have the benefit of the resources that you've already developed. So with all of those kinds of activities, front lines for training for court staff who are working at the counter and can be available as a court accessibility coordinator, for training like today for lawyers, for training for judges, and we hope with the government doing more to address these kind of barriers as it builds new courthouses and develops other activities that are involved in its oversight of the courts. We're hoping that all of those pieces can help make progress. That's not to say we're moving quickly enough. That's not to say there aren't new ideas. We welcome yours. And today, through emailed questions that you can send in right now, and we can try to address in the last half hour, that'll give you one avenue for dealing with that. Let me just wind up, and before we turn to our court's accessibility coordinators to get their input, let me just turn attention to one very specific area that I think merits your attention. I've been talking about this globally from the perspective of either lawyers or witnesses or judges or court staff. But as we talk to you today, any number of you watching this program today may well have a disability, and odds are you all will at some point in life. We, folks with disabilities, are the weirdest minority of all, because we are the minority of everybody. Everybody either has a disability now or has someone near and dear to them who has a disability now, or will get a disability as they get older. Aging is the most common cause of disability. So some of you may already have a disability. If you don't, you may think in terms of yourself as a person without a disability, but those of us who do advocacy in this area tend to think of you more as a person with disability in waiting. And you will want, should you acquire a disability, to be able to continue to take active part in your career. And there is no reason why you shouldn't. The important kinds of supports that will be available for lawyers who acquire disabilities, or paralegals who acquire disabilities, will be to talk to others who already have the same disability and who can learn from them about different strategies that can be used. There is no one-size-fits-all solution for any individual, including any lawyer or paralegal who acquires a disability. Some blind people use Braille. Others don't. A lot of people lose their vision later in life and will either learn Braille only to read notes, like I'm doing right now, or won't use it at all and will use other technology like the screen readers that are now widely available to run on a computer to either enhance the size of the text on the screen or to read aloud what is on the screen. That kind of adaptive technology is available all over the place and at way lower cost than it ever used to be. In fact, for some products, some computers, it comes built in. You don't have to pay anything extra for it at all. So there's no one-size-fits-all way to accommodate the needs of people with disabilities, whether they're practicing law or they're a paralegal or whatever. But you, should you acquire a disability, will want to be able to turn to others who already have that disability and have carried on with their career and can give you practical tips. We need more of an opportunity to get people together to learn from each other. I will tell you that I, some years ago, organized sort of a virtual organization called the Canadian Association of Visually Impaired Lawyers, where I reached out and was able to contact a good number of people with vision loss, totally blind or partially sighted, judges, lawyers, law students, law professors from across the country. We haven't met, we met once and we haven't really had much going on in recent years, but I do maintain the title of the organization. And again, if you want to contact me, if you're experiencing vision loss and want to know about practical solutions or to talk to somebody in your community who is closer to you, you can always contact me either through the Law Society or at david.lepofsky@gmail.com. We need comparable networks. By the way, in the United States, there are not one, but two different organizations of lawyers with vision loss who have national conventions every year. I've been to a couple of them, and there are tremendous opportunities to learn from other people how to carry on and how to be very, very successful and in your career, learning alternative techniques for doing it. There are lots of lawyers with different kinds of disabilities all around. If you have needs, it's important to reach out to others who have comparable needs. Let me just conclude my remarks by just pointing you to one other thing that you're going to want to know. It may seem a little tangential, but it really isn't. It's right on. Under the Accessibility for Ontarians with Disabilities Act, the government has developed and is developing and enacting and is obliged to enforce a series of accessibility standards. And these standards specify a number of measures that need to be done to help get us to a fully accessible province. Some of the standards have been developed, some are underway, and some have not yet been started but are needed. There are 3 areas that are covered right now that are relevant to accessibility in the courts, and they'll also be relevant to you in your law firms. So if you don't know about them now, you really want to learn about them fast. And we've got links in our materials on how to find out about them. Let me just take a moment to give you very quick highlights. The first one is called the Customer Service Accessibility Standard. It imposes certain requirements in terms of having a policy in place, a feedback mechanism, and having workplace training. This is relevant to law firms as well as the government itself to ensure that we deliver customer service that is accessible over the counter. Now, the government was obliged to meet those requirements starting in 2010, so your court accessibility coordinators could be seen as an outgrowth or an implementation of that, but it's also something you're going to want to think about within your own law firm itself. Second, last year the government passed an accessibility regulation that governs access employment barriers. That will be obviously relevant for court staff working in the courthouse. It also will have a bearing on you in your law firms. And finally, last year, as part of the same comprehensive regulation that included employment, they passed the standard that deals with barrier-free access to information and communications. Let me just focus you on one part of that. One of the things that the information, communication, accessibility requirements include is a requirement to work towards having fully accessible websites. Now, many of you might say, what on earth is a fully accessible website? People who use adaptive technology to use a computer need to be able to navigate a website, and depending how you design your website, our adaptive technology will work really well with it or really poorly with it. So, for example, using myself as an example, when I use a screen reading program on my computer and I go to visit a website, whether it's a government website or a court of appeal website or whatever it may be, if that website was designed to meet international accessibility standards, if the information is posted there in an accessible way, we can read it. If it isn't, we have a problem. So the government, to their credit, passed standards last year that are requiring first the government and then larger private sector organizations to meet website accessibility requirements. All of this, everything I'm talking about, is also required under the Human Rights Code and for public sector organizations under the Charter of Rights. The Disability Act doesn't actually impose new burdens. It just specifies a lot of requirements. And if the Disability Act standards are weaker than what the Human Rights Code would require, the stronger accessibility guarantees prevail. So what does that mean for you? It means for you that you want to make sure that your website is accessible, and if you go to a government or court website that creates accessibility problems for if you use adaptive technology, you want it fixed. The good news is there are international standards, there are easy-to-use tools available out there on how to do this, and accessibility for us, as is often the case, is beneficial for everyone. We're sitting, as we do this presentation, in the Osgoode Hall building downtown in Toronto. A new ramp was put in the front of this building a couple of years ago to make the front door have level access. That helps not only people using wheelchairs and scooters, it helps anybody who's got a bag on wheels. That means every lawyer who comes to argue a case in this building. Similarly, if your website is disability accessible, it is also far more accessible to people using a smartphone or PDA. Just as one illustration, a couple of years ago, or up until a couple of years ago, our Court of Appeal posted all their decisions in PDF and in HTML. HTML is generally accessible. PDFs can be inaccessible, despite the fact that Adobe claims they at times can be fully accessible. I don't agree. But in any event, a couple of years ago, the Court of Appeal decided to just post future decisions in PDF. I intervened and was able to quickly get them to change that practice, and now they continue to have their decisions posted in PDF and HTML. The first feedback I got on that was from one of my colleagues who was cited, who said that that was really helpful for him because he has trouble opening a PDF on his smartphone, but the HTML is way easier to access. So doing accessibility for us tends to help everyone. The requirements for accessibility of websites that apply to law firms will also obviously apply to the government, and it's important that when you go to a government website to see if there are services you need to know about for court access, that they're presented in a form you can read. Well, with all of that, let me go from this sort of general where are we at, how are we doing, to a very practical discussion for the rest of our time together on tools and ideas and tips for you. So the first thing I'm going to do now is I'm going to turn to two of our staff at the Ministry of the Attorney General who have been working and are working on the front lines in dealing with accessibility of court services in the courthouse across the province. We have two speakers. The first is Lori Mcavoy. She is the accessibility lead now? She's in the accessibility lead's office at the Ministry of the Attorney General. They try to oversee this province-wide for the whole ministry, and she'll explain how she has hands-on involvement with issues that can come up around the province. Also with Lori is Jeanette Sprove, who is the lead government official at the Ministry of the Attorney General responsible for accessibility supports in our Thunder Bay Courthouse. And they're going to tell us what they do and how you can make use of their services. So, Lori?
Thank you, David, and hello, everyone. And obviously, we drew the short straw. Having to follow David Lepofsky as a speaker is a bit of a challenge, but we'll do our best. So I'm going to give you the big picture of what the Ministry of the Attorney General is doing to improve accessibility court services across the province. And Jeanette, who is the Regional Accessibility Lead for Northwest Region and also the Supervisor of Court Operations in Thunder Bay, she's going to describe how our courthouse accessibility coordinators provide accessibility. She'll give you some examples, and she'll tell you how you can work with the accessibility coordinator at the courthouse level. So I want to start with three important notes, just three important things to keep in mind as we talk. One is that Jeanette and I are speaking about courthouses administered by the Ministry of the Attorney General and not the municipally run courthouses that the Provincial Offences Act matters, that hear those matters. Number two is you always have the option to use standard legal processes, such as a motion or a pretrial hearing, to raise requests for disability accommodation. You don't have to go through the accessibility coordinator if you prefer to use the other methods. The third point is that for criminal court matters, you do need to follow any processes set out in the criminal code if they address the accommodation request. For example, if you have a person with a disability who needs to participate remotely, there is a process outlined in the criminal code, and you must follow that process. So why is accessibility in our courthouse so important? The Ministry of the Attorney General is committed to ensuring equal access to justice for all Ontarians. This includes providing services and programs for people with disabilities so that they can use and benefit from our services in an equal way and free from discrimination. So what does that mean? Accessible services for the court means that people with disabilities can get into the courthouse, they can participate in a court proceeding, they can go up to a counter and use the counter services, or they can benefit from a program such as the Family Law Mandatory Information Program and participate there. They should be able to participate in an easy and convenient way regardless of the disability. The Ministry offers accessible services for litigants and accused. That seems kind of obvious. But we also offer accessible services for witnesses, family members, judicial officials, those under enforcement orders, jurors, members of the public, and of course for legal counsel. Anyone really who participates in services in the courthouse can request accessible services, and counsel can make requests on behalf of their client. As you know, the population is aging, and David referred to this, and the rate of disability increases with age. So in the course of your own career, you will likely have to consider accessibility for some of your clients or for yourself at some point. So let's start with some quick examples of what does accessibility look like in the courthouse. So a person who is deaf and uses American Sign Language to communicate, they need to participate in court or at a counter service. We can provide a sign language interpreter. The person who is deaf signs to the interpreter, and the interpreter translates the sign language into English or French. And through that process, we can communicate and get whatever the work needs to be done. Someone who is blind needs to read one of our guides or forms, such as information in the family law area, maybe information about divorce. They can ask for the documents in an alternate format, such as Braille, large print, on cassette tape, or in an accessible electronic format so that they can read it on their computer, as David mentioned. A witness who uses a wheelchair needs to participate in a case. The case can be moved to an accessible courtroom or a courthouse to accommodate the individual if that's necessary. A person with a panic disability must attend the mandatory information program. It's a required program. If the individual cannot attend the group session because they have issues with being in a group and being surrounded by a lot of people, we could arrange for a one-on-one session for that individual. Someone who's had a stroke affecting their speech must participate in court, and there's concern that they won't be able to be clearly understood. We may be able to arrange for a communication assistant, such as a speech-language pathologist, to assist. The assistant would need to meet with the person in advance and be able to, so that they can get to know what their speech patterns are and how they do communicate, so that in court they could interpret that and assist. This accommodation will, of course, need the approval of the judicial official because it is impacting on the communication in the court. Another example would be a legal counsel who's severely hard of hearing is provided with a service called real-time captioning, so that they can read everything that is said in the courtroom on a screen at the same time that it is spoken. So what's the current level of accessibility? Are you going to just walk into a court and everything's going to be laid out before you? Well, no. If we start with buildings, we have over 170 court locations, most of which were built long before accessibility was considered. The ministry is the first to say that we have a long way to go. Many of these courthouses are also heritage buildings, which are complicates how they can be renovated. It will take us time, but we are making improvements each year, and I mean, that's our goal. Be dealing with things each year, be moving forward so that we can get to that goal of 2025. David gave this example as well, but I'll repeat it in case anybody didn't catch it. We're in the Osgoode Hall Courthouse building, and it did have a number of stairs at the front. This is a National Heritage building. It's a gorgeous building here in downtown Toronto. And there were a number of steps up to the front entrance. And the concern in putting in the ramps was, the wheelchair ramps, was that railings and ramps would block the facade of the front of the building. So it took many designs. There was a lot of back and forth, but they did find a design that worked. And it was really a long, low sloping ramp. So very different than most ramps you see. It took a lot longer length so that the slope could be very low. And it was added in a manner that does not impact on the view of the building and yet makes it accessible to people who cannot use the stairs. As we renovate or upgrade areas of existing courthouses for any reason, we had a fire in Sault Ste. Marie this year, we had a tornado, we've had, there's always lots of reasons that things need to get renovated or fixed. We're including accessibility features such as accessible entrances, lowered counter for people who use wheelchairs, braille tactile markings on the elevators. These things are just being addressed anytime there's an opportunity to do them. And in our new courthouse buildings, we're adding even more advanced accessibility features. Some quite interesting that the ministry has worked through over a number of years to design, and they're still trying to perfect. But there's adjustable witness stands that can go up or down so that a person in a wheelchair can actually sit at the stand but be have the podium at an appropriate height. There's jury boxes where a section of the jury box can swing away to allow somebody in a wheelchair to sit in the jury box. And there's counsel tables that can also be adjusted in height. And again, this will ensure that witnesses, jurors, or counsel who use wheelchairs can all, as we have more and more new courts, will be able to just go into court and be accommodated as soon as they go in. Another key area of a challenge for us and what we're working on is the court forms and documents, and like David said, the websites as well. I wouldn't even hazard a guess as to how many court forms or documents the ministry has. As long as you know, most forms are governed by court rules. So once again, it's not simply a matter of us changing the design of the form. We actually have to work through the rules process, and so it can be complex to address. But like our buildings, we are addressing forms and documents on an ongoing basis over several years. So we're going about it through 4 different strategies. So if an individual needs a document that has not been made accessible, it's addressed immediately. So someone needs a certain form, we'll just take that and immediately address it, get it in an accessible form, and get it back to them. Number 2 is we're identifying our most frequently used forms and addressing those first. So we're going through a process of what is most often used. Let's get those number of 8 done this, in this next quarter. Then we'll move on to the next bunch. So that we're always working away at the big backlog of forms that we need to deal with. And when a form or document is updated for other reasons, say there is a rule change, then we address accessibility at that time as well. And any new forms or documents we're designing must include more plain language, plain and simple layouts, and be easy to read by devices that people with disabilities may use to read with on their computer. David referred to this a bit. And again, somebody blind or visually impaired may use a device called screen readers, and it reads out the text to them of what's on the computer screen. And so they hear it in a voice. People with physical disabilities, someone who can't operate their keyboard or their mouse, may use devices that they're able to control by speech. So by talking to the computer, they're actually able to input text. They're able to control where the cursor goes and actually operate that computer. And with a document, they can cut and paste and do the work that they need to do if we give them that document in an accessible format. And again, as David referred to, there are international standards called the World Wide Web or W3C Web Content Accessibility Guidelines. That's what we're working towards for all our any new websites or any new documents going on to our websites so that we can be sure they're accessible going forward. So a few other efforts that we're making. In addition to buildings, documents, and websites, the ministry is working hard on improving accessibility in other areas, such as our administrative process and counter services are being reviewed when barriers to people with disabilities are identified. I find it's often the easiest way to identify barriers is to actually work with somebody with a disability through a process, and then the barriers are quite clear. And what we're doing is we're being very careful to capture any of those issues and track them so that over time we can address them. We're improving communications with people with disabilities. For example, we're currently making a sign language video of the video that's used in the Family Law Mandatory Information Program, so that we will have a sign language version for anybody who is deaf. We're reviewing legislation for barriers to people with disabilities. And we're creating greater disability awareness among our staff by ongoing training and information. And finally, we're trying to get the word out that people with disabilities can ask for accommodation of their disability. I know we were talking before saying some coordinators get a ton of requests and others not so much. So we really want to make sure that everybody out there knows that this is available. So our website offers information on our commitment to accessibility page. You can find that on the very first page of the ministry website. All of our permanent courthouses now have signage that tells people they can talk to the accessibility coordinator. Any staff person can direct them. And we're adding information about our courthouse accessibility coordinators to key forms and documents as well, so that they know who to contact. Even with all these proactive things the ministry is working on to make our courthouses and services accessible, in my opinion, I would still say that the Courthouse Accessibility Coordinator Service is the most significant accessibility initiative of the ministry. There are staff with the role of accessibility coordinator in each of our permanent courthouses across the province. You can also request accommodations for our satellite and fly-in courts through the base court location. The accessibility coordinator, as David said, provides a one-stop shop approach, and that's really important because they're getting information about all the different kinds of requests. We're learning from this, we're building knowledge, and it's easy for people to find the right person. And that's what's really important and an advantage in this model. And the role is so important because accommodating someone with a disability is often very much about the individual and the tasks they have to perform. It's not like there's a list of accommodations and you just stick it here or there. It's really about the person, the way their disability impacts in the courthouse situation and what they need to get done. So there's no one solution for everyone. Even with the same disability, people will need different accommodations. And by having the coordinator there to work one-on-one, we're able to give that individualized approach. So, for example, hearing loss. Some people who are hard of hearing won't need any accommodations in the court. They'll be just fine. Others might benefit from speakers in the courtroom if everybody's using microphones. They'll be just fine with just the microphones. Still others, such as myself, would need assistive listening devices, which actually plug into the mic system but send the information or the sound directly to either a headset or to work with the person's hearing aid. So you get much more direct sound and you can control the loudness of it. So for many people, assistive listening devices are very important. And for those who cannot rely on their hearing, there may be a need for real-time captioning. This involves a dictatypist, like a court reporter, who has special software that translates the short forms they've typed back into full words, so that a person can read what each person is saying as they say it. It can be displayed on a computer screen or a large screen. So everything that's said in the courtroom is actually typed up there, pretty much real time, might be a second delay or so, and then you can follow along that way. I know somebody was telling me they just did a victim-witness situation. The person had used captioning in the interviews, but then in court, and they were very confident in court and presented very confidently, but prior to not knowing they were going to have that, were very nervous and tense about even going into court because they were afraid they weren't going to hear. So another area that is a good example of individualized approach is mental health disabilities. So just because there's such a range of impacts. Certainly medication impacts people with mental health disabilities, but it can impact in very different ways. For some people it makes them groggy, other people are restless. So it's not like there's just sort of one solution. You have to focus on how the disability impacts on the task the individual needs to perform in the courthouse. So, for example, we had a situation where someone had an assessment hearing. They were on a lot of medications for mental health disability that impacted on their stamina, and stress was a major factor. The barriers to this individual appeared to be that they would not have the stamina for a series of 3 days in a row, and that the anxiety could overwhelm them. So in addition to the individual asked to have a family member as a support person present with them, sitting beside them. First, it had to be checked out that the family member would not be called in the hearing, and once that was cleared, it seemed acceptable to all parties. When the defined role of the support person, I think that's important. It's important to have the defined role so that the support person knows what they can and cannot do. The person with a disability knows what the support person cannot do, and the other party is aware of why they're there and what they're going to do. And then the last was their scheduling changes was to address that, just to allow the individual a little bit more recovery time. So I think they did a day, and then they did a half day, and then they did a day, and the person was able to handle that. So these were all things that were put forward to the judicial official, and they were agreed to once consideration of the other party had been made. So, so the role, let's go back to the role of the accessibility coordinator. Courthouse accessibility coordinators are the main point of contact on accessibility for court proceedings and counter services. Coordinators can tell you about the features that are in their particular courthouse or the courtroom you are using so that you can determine if any accessibility measure or disability accommodation is needed. Sometimes people don't anticipate that they're going to need an accommodation because they just don't know what they're going to face. They may not realize they're going to be at court for that long time, so or for the full day. Where accessibility features don't currently exist, our courthouse accessibility coordinator is the key to providing an effective disability accommodation, such as moving the case to another courtroom or courthouse with the permission of the judicial official. The coordinator can handle most accommodation requests on their own, for example, guiding someone who is blind to a courtroom or counter service or arranging for equipment. They'll usually inform the judicial official in advance. In some cases, the judicial official will actually need to make a decision on the disability accommodation request. Accessibility coordinators can also contact the Ministry Accessibility Unit, which is where I work, for advice on accommodation options and resources. So it's really important to connect with your local accessibility coordinator. I believe that there's a link in your package to the addresses, and I'm just going to turn it over now to Jeanette so that she can tell you about some of her experiences as a regional accessibility lead.
Okay, so thank you, Laurie. I'm going to talk to you about what currently comes through the doors of the courthouse and to some everyday requests we receive, and as well as one more complex case. As always, if we have advance notice, if someone requires assistance, we do everything possible to make sure we can accommodate the request. And most times we can let you know at that time when you're asking if we can accommodate. For some disability accommodations requests, we need to have the coordinator ask approval from the judiciary. Other times we need to find a place to rent something or borrow some specialized equipment, find a service provider who's available for those dates and times. All this takes time, and many times, you know, in many services, such as a captionist, we need a couple of weeks. One of the most common requests for disability accommodation across the province is for assisted listening devices. As Laurie said, these are permanent or portable systems that connect to amplification systems and send the sound to anyone speaking in the courtroom to a headset. And sometimes it can go directly to their hearing aids. In my region, most of the courthouses, even the historic buildings, have some form of hearing assist device. And by March of this year, all courthouses across the province will have at least one assisted listening device in the courthouse. If the accessibility coordinator knows ahead of time someone needs an assisted listening device, it gives us time to inform the judiciary of the request and have the equipment ready and right in the courtroom. Having the time to be ready makes it a much more seamless process and avoids delays in any of the court proceedings. It's important to know many people who wear hearing aids have never used an assisted listening device, so you may need to talk to them about them, ask them if they need the amplification or not. It might even be possible to arrange for that person to come in advance of the court day and have them try it out. People who are hard of hearing are often really anxious about going into court. An assisted listening device can make the difference between a nervous witness or a confident one. Many times we have people who are using walkers, canes, they're fatigued or frail as a result of their disability and have difficulty walking or taking the whole day in court. While we don't have wheelchairs in every courthouse, we do have some, and we can rent them if necessary. And I think for a client in this situation, you need to think about how they will get to the courthouse and get in. And you can talk to the accessibility coordinator to find out where that person can be dropped off, the most direct access to the courtroom, so that they're not spending all their energy getting just to the courtroom. We can also accommodate people at our counter. For example, you know, if we have an individual with a mental health disability, we can accommodate by moving them to an accessible counter. They can sit there, it's generally more quiet and less crowded than our regular counters, and they can more easily have a family member sit with them, and we'll work with them to make sure they can file their documents. We find that moving away from the standard counters sometimes puts them at ease. In Northern Ontario, we have fly-in courts where the court party goes to a First Nation community in what we lovingly refer to as culverts with wings. The court is held in a community center or the lobby of a hockey arena or some other location that can accommodate the court. Court flies into the community and they have a small accessibility toolkit. This kit includes a portable hearing assist device, some magnifiers, some large pens, and these tools can assist someone if they have a request. For many restrictions, we have restrictions on the plane, so we're limited to what we can bring, but anything we can bring is always sort of appreciated. The ministry encourages feedback, positive or negative, about accessibility. It'll help us to know what is working, where we need to improve. It also helps us identify barriers for people with less common accommodation needs. You can give us feedback to any staff or to the accessibility coordinator. You can send it by letter. You can use ministry email, the phone number or TTY lines for people who are deaf. And all this information is available on our Commitment to Accessibility webpage on the ministry internet. And the link to this site is in your resources. And ministry staff and managers will work directly with you or the person with the disability to address any complaints you offer in person. So what can you do? You can talk to your client with the disability about what the day is going to be like and what the client or the witness or the family member can expect so they can anticipate what their needs are. So, for example, someone who takes medication may need to keep that medicine in the fridge. Someone else may have diabetes. They may need to have food with them. It may be a very long day. They need to take a break. A client who has fatigue issues may need to take extra breaks in the proceedings. This is all something that you'd want to discuss ahead of time, because then you can notify the judiciary that these are a requirement. The accessibility coordinator can talk to you about these and many other types of these issues. And so most importantly, call us early. As you know, courts are very busy places. The more time you give us, the more smoothly the accommodation will go and the better your court proceeding will be. So I'm going to leave you with one final example, and this was uncommon and a very complex accommodation that we had. But it speaks to the importance of everyone being able to have their day in court. This accommodation did require the approval of the judiciary, and we had prior notice of all the requirements. We had a witness who was terminally ill and was unable to travel to Thunder Bay, where the case was to be heard, and was really motivated to provide the testimony in the Superior Court matter. In conjunction with the judiciary and 2 levels of court, we were able to bring the witness to an Ontario court in Dryden, and that was very close to where this witness lived, and there was video equipment made available to them. We also provided a room with a cot for the witness so they could rest in between the testimonies. This witness was on oxygen, so we had oxygen equipment, and it was quite noisy in the courtroom, so we had IT staff come and adjust all the levels so that we could have record of the proceedings and just make sure the witness was heard. And the individual also needed a personal support worker, so we had to have a place for that personal support worker to stay. On top of that, it's winter. The counsel for the other side is stranded in Ottawa by weather and is unable to fly to Thunder Bay. So in normal circumstances, this would be adjourned to another date. But considering the witness, their terminal health, it couldn't be put off any longer. So in a very short period of time, we were able to have counsel in Ottawa situated in a video suite at the university on the first day, and on the second day in the Ottawa courtroom where video equipment was available. We then had the video suite in Thunder Bay where the judge and staff were located, and then in the courtroom in Dryden where the counsel and the witness attended. The testimony went over a 2-day period using these 3 locations. I have to tell you, I was so humbled by the tenacity of this witness and their commitment to providing testimony for this trial. Everyone involved made accommodations to have this testimony presented, and in the end it was successful because, in terms of the disability accommodation for this process. So this person had their day in court. Both the judiciary and the counsel commented on how smooth the process went considering the complexity of the accommodation, and it was the commitment of everybody involved to make it work that made it successful. So in the end, the witness had their day in court, and I regret to say that they passed away very soon after this day. So when you require accommodation in one of our courthouses across the province, whether you know what your client or witness needs or what can be done, talk to the accessibility coordinator and work together. Accommodation of people with disabilities is sometimes about problem solving and being flexible, and if we can all work together, we can make our courts accessible. So on behalf of Laurie and myself, I'd like to thank you for this time.
Thank you both very much. Just so you know, the frontline coordinators deal with the over-the-counter requests you bring in. If it's one of those complicated cases like the one that Jeanette was just talking about, they may end up going to Laurie's shop at headquarters to help come up with solutions if they can't just figure it out at the courthouse. So they're trying to arrange that backup for the more complicated issues. It's really important also for all of you watching to understand that this is one piece of what government does. Government's very busy. We will only get more progress in this area if you make full use of the court accessibility coordinators, and if you can't find solutions or you're encountering recurring problems that they can't fix, that you let the ministry know, and they can let us on the Ontario Courts Accessibility Committee know, so we can try to find bigger solutions, more long-term solutions. So let's move on to the next part of our show, and it's this. So the lawyer's in a unique position to find out from their witnesses, from the clients, from family members, if there's a disability need and an accommodation need. And a lot of that can get addressed if you bring it early enough to the court's accessibility coordinator. But there's another key player, and that's the judge. The judge runs the courtroom. The judge is responsible for everything that goes on there. And we want to spend the next half hour talking to three experienced, dedicated, and well-informed judges, all members of the Court's Accessibility Committee, to kind of learn about the view from their side of the bench, aimed at providing you with practical tips. All of them were very experienced practitioners before they became judges, so they could really, they'll be answering from both viewpoints, from theirs behind the bench now and previously from behind the council table. At my far left and your far right is Justice Anne Malloy of the Superior Court of Justice. Everybody's bios are available under your material tabs, and so I'm just giving the one-liners. Before Justice Malloy got on the bench, she had an illustrious litigation career, including, I hope I make you blush, being, I believe, one of the finest, if not the finest, persons to argue disability issues in any court as counsel. Beside her, and in the middle of our panel, is Justice Howard Bornstein of the Ontario Court of Justice. He was a criminal defense counsel for years, and then is now a judge hearing criminal cases in the Ontario Court of Justice, sitting in Scarborough here in Toronto. And finally, to my immediate left, and to the viewers' immediate right, is Justice Stanley Sher, Ontario Court of Justice, previously a family practitioner, now sitting in family cases in North York, Northern Toronto, whatever they call it up there. He's multitasking, because while we're talking, if you're emailing him questions, he's pretending that he's listening to me, but he's also checking out his iPad to figure out which questions we're going to ask next. So if he looks a little distracted, it's only because we've asked him to do two things at once, which is completely unfair of us. I'm going to do this as kind of a Q&A, and we're going to while I direct questions, everybody's welcome to jump in. I'm going to start with Justice Malloy. So from your point of view as a judge, you go in there and your job is to hear evidence and argument and decide cases. So what's your role on this disability accommodation thing? Like, what do you feel is your responsibility as a judge in terms of making sure that accommodations are delivered to court participants with disabilities?
I think my role as a judge, a trial judge, in dealing with disability is no different really than in dealing with other issues that are before me. I'm responsible for ensuring there's a fair trial. The trial is not fair if one of the participants is not able to participate fully because of a disability. That applies to witnesses, that applies to lawyers, it applies to jury members. So I have that responsibility. I have it just because I need to conduct a fair trial, and also I have a charter responsibility because the administration of justice for people is required to accommodate their equality needs. So I have that responsibility, but in fairness to me and my colleagues, I can only do so much. I can't put in a ramp. So there are certain structural barriers that I cannot do anything about in a tangible way. What I can do is direct that the hearing proceed somewhere else. I can't go out and buy equipment, but to the extent equipment exists, I can direct that it be brought in. I can adjourn proceedings until appropriate equipment is acquired. If I have advance notice of things, I can accomplish a good deal. And if I know what I'm dealing with, I can accomplish a good deal. But I guess what I have to say to lawyers is, please tell me. The other thing is that the accessibility coordinators are often limited in what they're able to do. They are employees of the government. They've been given a set of tools, and somebody calls them and says, I need this accommodation, and they can sometimes be told, we don't do that. If that's the answer you're given by the accessibility coordinator, that, as a lawyer, you shouldn't accept that that's necessarily the end of the case. You can still apply to the trial judge or bring a regular motion if it's a civil matter. You can still apply to have that accommodation put in. So that would be another role for a trial judge in that situation.
Justice Bornstein, could you expand on that, and also tell me not only how you see it, but what you understand your colleagues on the bench understand their role to be?
Well, I think that I agree with everything that Justice Malloy has said with respect to what my colleagues, their views are. In truth, it doesn't come up that often. I think that people on the bench are aware of, first of all, the absolute necessity of ensuring a fair trial, which includes, as Justice Malloy has just said, ensuring that counsel, the litigants, the witnesses are able to participate fully, and so therefore to do whatever you can to ensure access. But in terms of what an individual judge may know about the issue, it really depends largely on their own personal experience. I think they're all very anxious to help if it's brought to their attention, and really I suppose one of the key points to take away from the seminars, as already obvious, is the responsibility of counsel to advise the bench, because for the most part we don't know what's required, and if we're told what is required, we will do whatever we can to ensure that you get it. But in terms of what individual judges do or don't know, it really depends on their personal experience.
David, if I can just weigh in on this issue.
Sure.
I sit in family court, and we operate on a case management system. And for those who don't understand what that is, it means when a family comes into court, there's one judge assigned for that case right up until trial, and there might be multiple appearances. So family court's a little bit different perhaps than criminal or civil court with respect to this. It helps at the earliest opportunity to let us know in the case management system if there's an accessibility need, not just for your client, but also for the lawyer as well. For it to be a fair proceeding, and that's what every judge wants, we want to create an environment which is conducive for everyone giving their best possible presentation. Family court is a scary place. People are emotionally charged, and if you have a disability which is not being accommodated, that's only going to exacerbate the issue. And sometimes people, your clients, won't be willing to come forward and let you know what those issues are. They might be literacy issues. It might be the need to take frequent washroom breaks. It's something that you need to canvass with your clients at the earliest opportunity and either address with the accessibility coordinator or address with the case management judge as early as possible so we can accommodate that. And there's all kinds of things we can do. We can set up special scheduling. We can set up a special courtroom. We can get equipment for you. So there are things that we can do if you let us know.
Okay, Justice Malloy, we've got folks, several hundred around the province watching us, for whom this may be the longest discussion they've ever heard about this from the perspective of judges, lawyers, courtroom, and court staff. When a lawyer's going to get up in court and ask a judge about this, what should they expect the judge knows or doesn't know about the accessibility needs of people with disabilities generally? Are they getting trained on this? Should we assume they're starting from a blank slate? We take your the information you've shared that they want to do what they can, but what should we assume they know from the starting point?
They know about the duty to accommodate. They know what that requirement is. They will have had some ongoing education about the duty to accommodate and about accommodating certain disabilities, all disabilities. What they can't know is everything there is to know about every disability, everything there is to know about how those disabilities have an impact on particular people. That's not knowable, in my view. Even people with considerable expertise in disability issues can't know all of that, because the thing about disability is it has, even the same disability has a different impact on different people. And so you can't possibly expect the judge to know if you just say, this is a person who has this condition, that judge will now know what needs to be done to accommodate it. So I'll give you an example. In my previous life, before I was on the bench, I worked at the Advocacy Resource Center for the Handicapped. And it's a legal aid clinic doing test case litigation for people with disabilities. Its a board of directors is comprised entirely of people with disabilities. So day 2 on the job, 2 members of our board, so by definition people who have disabilities, came to take me out for lunch. One, her name is Carol, had a guide dog, a lovely black Labrador retriever named Bounty. And the other, Liz, walked with a noticeable limp, and she had a cane. So I immediately assumed that Carol was blind and that Liz had a mobility impairment. So we went for lunch, and we sat down at the table, and Carol picked up the menu. She's the one with the guide dog, and she read it to Liz, who was completely unable to read because of low vision. The nature of Carol's blindness was that she couldn't see anything in the peripheries. She could read, but she needed a guide dog to go from point A to point B. So even looking at people and knowing one was blind and the other had a mobility impairment, I had no idea what these people needed in terms of an accommodation just to have lunch. I can't be expected to know anything in a courtroom if you don't tell me straight out what is needed.
Justice Bornstein, just building on that, when you walk into a courtroom, like we know the courtroom from the point of view of the counsel table, we're all in there. You walk in from the bench. What, if anything, do you know about whether there are anybody with disabilities in the courtroom before anybody actually tells you about it? What can you see from up there, or what do you notice?
Well, unless it's obvious, somebody's in a wheelchair perhaps, or somebody has a cane, unless I can see something that obvious, then I won't know anything unless advance notice was given to the clerk or to the accessibility coordinator, and I may be told that somebody has an issue that is going to require frequent breaks or a different schedule, earlier lunches, earlier meals. So I may know that in advance, but if I'm not told something specific, then it would just be what is apparent. So the bottom line is we need to be told. And that requires counsel to find out, as Justice Sher was saying. And just by way of example, I probably do 150 judicial pretrials a year. And in each one of those cases, there's at least 2 participants, and probably with witnesses up to 10. And in every single case, as is on our judicial pretrial form, I always ask counsel, is there a disability that needs to be accommodated in this case? And I don't think I've ever had counsel say yes.
I haven't either.
So if you do the math, that must be 1,000 people coming through the court, not a single one has a disability to be accommodated. That's obviously unrealistic. That's just counsel, and maybe we were all the same way, not really sort of exploring the issue in any way other than what is most apparent to counsel.
And just to give everybody a little context, in Ontario, at least 1.7 million Ontarians now have a disability. The number's growing because, as we said earlier, the biggest cause of disability is aging. And we know that people with disabilities are disproportionately represented among people who are involved in criminal proceedings, either as complainant or as accused. So that that you haven't heard means that we as counsel have to be doing more to make sure we let you know. Just to share, what do you need to know and what don't you need to know? I know this may sound a little stupid, but do you need to know about their medical issues, or how much should we be telling you?
The minimum amount necessary for me to accommodate the accessibility need. I want to respect the person's privacy, and I don't need to know any more than I need to know to be able to facilitate that accessibility need. So if the party doesn't feel that their accessibility issue is relevant or doesn't need to be facilitated, I don't need to know about it. But if it does need to be accommodated, I want to do everything in my power to help.
Now, all three of you have said you need to know, let you know soon. And that message is now being widely disseminated through our discussion here. Just a couple things that flow from that. One of which is, if somebody tells a judge at a pretrial on a civil or a criminal or family matter, or if somebody reports to the court accessibility coordinator in advance of a case, weeks, months before it reaches trial, that there is a disability need, should counsel watching this discussion this afternoon assume that reaches you, the trial judge? Should they walk in the courtroom, just carry on because they assume you heard it, or what should they expect? Can I start with, I'm going to ask all of you, but Justice Mcavoy, can I start with you on that?
I don't think it's safe to assume any kind of information flows fully and freely in any government environment. So usually I find out, usually I'm told, but nobody should assume that because you told person A, it's going to get to me. But for the most part, it does work.
Justice Bornstein.
Well, I think you obviously have a right to assume it will be addressed, but in terms of whether we would be advised, it would depend. For example, as I said, there's the judicial pretrial form. That's supposed to be recorded on that, which would be made available to the trial judge. So if my colleagues are being told, contrary to what I'm being told, that there are issues to be accommodated, then I should be made aware of that when I see the judicial pretrial form at the trial. If it's the accessibility coordinator who's told that, then chances are, I assume, I wouldn't be told unless it was the kind of thing that would require me to be told about scheduling issues. So presumably that would be done in advance with the accessibility coordinator and accommodated by the accessibility coordinator.
Justice Sher.
We have a very good accessibility coordinator at our court, and she's right on the ball. She comes to me immediately. So in my court, I'm going to find out, but I wouldn't assume in every court. I think there's going to be a learning curve on these issues, and it depends on which court you're in. So the safe bet is always not to assume. I can tell you, because we work in a case management system, I actually keep notes on every single one of my files so I can know what the families are about, and I flag accessibility issues immediately, so I know in advance of any court date that case is coming back to me, needs to be that issue needs to be addressed. If it needs a special courtroom, I'll make arrangements to put it into a different courtroom for that day. So in our court site, I know the information's flowing very well, but I wouldn't assume that's the case everywhere.
Can I come back
Sure.
to something that we were talking about earlier, and that is the level of detail that I need to know. I do agree that we must respect privacy, but sometimes, for example, where the accommodation is going to impact the rights of other people in the proceeding, it will almost be like a contested motion whether this accommodation is going to be done. Say a witness wants a particular accommodation that's going to result in a trial now being put over for another year or more, and an accused person wants his trial now. In that situation, I will conduct a much more detailed investigation of exactly why this person wants the accommodation and whether it can be supported, as opposed to is this some kind of ruse for getting out of something. So it really depends on the circumstances. And when I was counsel in cases way back when, I often called a witness in a trial where I had a person with a disability. I would often call a witness who would talk about the nature of the disability and how it impacted that person and what kind of accommodation was necessary. So I highly recommend that. It doesn't have to be a doctor. It can be just somebody who knows the person, sometimes with a mental health disability, for example.
You're talking about to educate the judge on the disability if it needs to be considered in the case.
That's right.
Have any of you, I'll just go through all of you quickly on this, have you had situations where an accommodation need has popped up, like literally right in the middle of the trial, unexpected? Justice Mcavoy, can I start with you?
Yes, that's the way it almost always comes up.
Justice Bornstein?
Well, but just to give you the other side of that, I was asking my accessibility coordinator the other day about this, and he said other than requests for interpreters, 95% of the requests that he receives, and by the way, he said he receives only 1 or 2 a month, and we're sitting in Scarborough, we have 13 courts going. So I think despite the signage, people are not sufficiently aware of it. And obviously that's the message we're trying to get out is become aware of it and start doing it. But he gets it 1 or so a month. And he said of those, most, 95%, are in fact in advance, not on the spot.
Justice Sher, just quickly, with all your case managements, is it working such that these aren't popping up unannounced?
They occasionally pop up unannounced. Sometimes we go through the case management system, and because we don't know about the need, you find out at the very end. So one of my jobs at the court is to assign trials, and I had one recently where I asked the lawyers, as I always do any of the witnesses, do any of the parties have any accessibility needs that need to be accommodated? The lawyers, as usual, said no, and then the litigant actually tugged on his lawyer's arm and said, I need captioning. And he had gone through the entire case management process without any captioning. So one questions how fully he had been able to participate in the process.
So the message is that counsel can do a whole lot more, a whole lot sooner, so the judges could do more and a whole lot sooner on this one.
Absolutely. The case management judge probably would have been a lot more successful if the litigant had come forward, and that could have been addressed.
I want to just do a quick discussion of individual disabilities, and because time is tight, I'm going to move a little bit more quickly. But Justice Malloy, someone in the courtroom has a fatiguing condition. They cannot testify all the way for 2 hours, or they can't wait for their case to be reached at 3 in the afternoon. They have MS, or they have fibromyalgia, or some condition. What can you do for them if you're told about it?
Oh, this is a fairly common one. It comes up fairly frequently, not just witnesses or parties, but even jurors. I'm very flexible about that. Short sitting times, more breaks, stopping early, or even just having the person say, I need a break now, and I just do.
Okay. Justice Bornstein, some people are on meds that make them have to go to the bathroom fairly quickly on fairly short notice. They can't wait for a break. And courtroom is a don't speak until spoken to kind of place. What can someone do to discreetly alert you to this without embarrassing themselves in front of everybody, and what can you do for them?
Well, again, that's got to be counted. If the witness raises it, I'll deal with it, but it is embarrassing. It's embarrassing at any time for somebody to raise things that have that potential for embarrassment, but counsel should deal with it. Obviously, judges would accommodate it, but that has happened to me, actually, where I've been told that a witness actually has that, and I just said, if that happens, just say, excuse me, I need a break, and we'll stop right then. That was the witness.
Okay.
Well, also, we've located the courtroom close to the washroom often in those
cases.
cases.
That's a good point. If they know about it in advance, they can try to get a courtroom that's near to a bathroom. Just to share, this is like somebody shows up in a wheelchair and they can't get in the witness stand. Where do they testify, or where do they testify?
Well, that shouldn't happen. If we know about that ahead of time, again, we can get it into a courtroom where that won't be an issue. But let's say it does happen on the spot. One thing I can do is I can see if the other courtroom is available. That might be difficult on short notice. If worse comes to worse, we'll swear them in from the counsel table or from the body of the court, and we'll do it in that fashion.
And actually, just on that point, David, somebody told me yesterday that they had a case at Old City Hall where the witness was in a walker, and rather than having the witness try to sort of climb the stairs to the witness stand, She just sat at the corner of counsel table. Both counsel actually stood when they examined her, but she remained there rather than having to struggle to get up to the witness box. And everyone was fine with that, obviously.
One of the things we've done, David, in a couple of cases, in fact, with this is we've actually changed the physical structure of the courtroom. We might just move tables around so the counsel can face the person in terms of doing an examination. We've done this before. And the whole idea is to make it as comfortable as possible for that person so we can get the maximum benefit of their evidence.
Justice Malloy, people who are deaf or deafened, meaning they lost their hearing, deaf meaning born deaf with hearing loss, deafened meaning they lost their hearing in life, or hard of hearing meaning they have some hearing. We've heard about sign language already and about captioning. Are there other accommodations that can be provided to assist them in the courtroom? And what can you, the judge, do about it?
Well, we do have the assistive listening devices for people who have some hearing that can be helpful. The big problem, there are two problems. To the extent somebody needs to have a sign interpreter, those skilled interpreters are in short supply. So it's sometimes very difficult to be able to set that up. And we're also now switching over to a new kind of court reporting, which is all digital and voice. It's more sound recording. And we're losing a lot of our real-time reporters who do the captioning. So that we have flagged as an issue that we need to retain some of those people so that we are able to do closed captioning type.
What about lip reading? They've got to have line of sight.
Yeah.
What do they do if the lawyer's facing one way and the witness is facing the other way? Are you prepared to let people sit somewhere different?
Of course. Yeah, that's not a problem at all.
But they have to ask.
Well, nobody knows until they ask.
Right.
Yeah.
By the way, we're going to go to about 1:35 with this panel before we start taking questions, because there's a lot in here and there's just a bit more I want to make sure we can cover. People with cognitive or intellectual disabilities may have trouble following the complicated language that we speak in the courtroom. Lord knows lots of people have difficulty following the language we speak in the courtroom in any event. But let me just ask Justice Bornstein, if someone's in that situation, what can the judge do to help if they're alerted to it?
Well, if it becomes apparent or if they're alerted to it, obviously nobody really wants to be seen to be unfairly examining a witness, or nobody wants to be unfairly examining a witness, and so a suggestion by the judge, or at most a direction that they use language in shorter packets and simpler language would be heeded, obviously.
Justice Sher, people with mental health needs in the court proceedings, if you're aware, if it's brought to your attention, what kind of accommodations can you, the judge, try to put in place during the actual formal court proceeding itself?
There's a fair bit that the judge can do, and there's a lot of strategies that the judge can do, especially in family court. And as I said, the mental health issue can exacerbate the tension and the emotionally charged atmosphere. What I can do is I can find out, are there times of the day where the individual operates at functions better, and I can schedule the case for that time. I also would probably want to clear out the clutter and the noise of the courtroom, and I might close the courtroom for that particular proceeding so it's a more relaxed environment. I set up a proceeding with structure. I find that when there's a lot of structure and rules that are followed, that calms down the environment and it allows everyone to be able to relax, not just people with mental health difficulties. And I try and create consistency. I'll speak more slowly. I'll break it down into bits. I'll ask for repeating of information to make sure that everything's being processed. I'll repeat positions. I'll seek the help of lawyers and ask them to model the same type of behavior in the court as well, so that we can focus everybody on resolutions. And so there's a lot of strategies that we can use in those situations. If the person would feel more comfortable with a support person, whether from a community clinic or even a relative, we have that person in the courtroom with them. I want everyone to function at their best in that situation.
Justice Malloy, we've been talking about kind of the more traditionally discussed disabilities. What about if somebody has an environmental sensitivity where they certain perfumes or floor cleaners or whatever will set off an allergic reaction? They can't even be in the room. If you're aware of that in advance, what can you, the judge, do about that?
Depends on the severity. This has actually come up in our courthouse a few times. We are now using cleaners that environmentally sensitive cleaning products, and we have done trials where we asked all of the staff not to wear any kind of scent, but depending on the degree of sensitivity, some people can't tolerate even like the carpeting or the kind of paint, or it's very, very difficult. In those situations, the only accommodation that seems to work is to take that person's evidence or have them participate remotely with video conferencing. And we have done that. I haven't done it personally, but I'm aware of it having been done for an environmental sensitivity case.
I'm going to take 1 minute to take on myself just to talk to everyone about people with vision loss in the courtroom, either as counsel or as a witness, just because it's the world I live in. The best thing in the world in a trial courtroom is a person with vision loss. No, I'm not self-promoting or marketing. The reason is because as soon as there's either a juror or a lawyer or a witness with vision loss in the courtroom, counsel have to narrate everything for the record, which of course is what you're supposed to do for the record anyway, but counsel sometimes slip. You will find that if anything that you need to describe for someone like me to be able to understand what you're talking about with hand gestures by a witness or contents of a document or whatever, makes the record a far better record. On the issue I raised earlier about the judge being able to see from the bench who has a disability and who doesn't, I've had some personal experience with this because, of course, when I come in the courtroom with a white cane, the judges aren't there. And by the time I take my seat at counsel table and put my cane down and they say, all rise, I stand up. I don't have a cane beside me, so the judge won't necessarily know. If I've been in the court a lot and they know me, that's fine. But even if the judge has been alerted to a disability, it is quite natural as the case goes on for them to forget. In fact, I learned early on that one way judges tell counsel it's your turn to talk is to nod at you. And if you're blind, they can nod all they want. You won't know they're doing it, and they'll think you're ignoring them, and so on. I've even early on gone in my career long ago, gone into to the judge's chambers with opposing counsel and just said, look, I can't see, so if you want to call on me, Your Honor, I'd appreciate if you call me by name. Judges always appreciate the heads up on it. Invariably, they'll forget at some point. The trick, and they'll nod at me, and I won't know. So the trick I've learned to get around it, yes, I'm giving away trade secrets, is when I'm not on my feet arguing, I'm always looking down at my notes. Because a judge who looks at counsel who's got their face down looking at their notes never nods at them. The judge will always call them by name. It's a body language gesture, the head turn, that does that. But it's important to remember that even if the judge is alerted, with all that's going on in the case, they may well forget. The last thing I want to ask you all about is terminology, language, and mistakes. There's a million different terms for disability. Judges won't know it all. How can we best alert the judge of what terminology is helpful to use to describe a disability? And also, what if the judge makes a mistake? They just inadvertently use a term that's not helpful. What should we, as counsel, do? Some counsel will be reluctant to say anything because they don't want to look like they're correcting a judge in the middle of a trial and get the judge upset with them. Justice Malloy, can I just throw that at you really quickly?
Judges just want to be told. We're very accommodating. A lot of judges are worried about using the wrong language. They don't want to say something that's offensive. They're not sure what the appropriate term is for any given disability. And in truth, that they change, from time to time. What's politically correct 10 years ago is not politically correct now. So judges will not be offended if you simply tell them that this is the appropriate language to use. They will have no problem with that.
The one thing for counsel to know is that because the terminology just does change a lot, the one that we really encourage people not to use is pejorative language. Sometimes people will talk about somebody suffering from a disability or confined to a wheelchair or those kind of terms that make disability seem like a negative thing. For those of us who have a disability, it's a part of our life. It's a normal part of our life. We don't view it in that kind of pejorative language, and we prefer if others don't either. I want to thank you all for this. This has been really helpful, and we're going to move into our last few minutes together. And I'm going to pass it to Justice Sher, who has been reading what questions were sent in over the couple of weeks leading up to now, and any that have been sent in now. And you can lead us through till just a couple of minutes before the hour.
Good. Okay, so Lori, we heard about converting documents to an accessible format. The question is, who pays for that?
Good question. If it's a ministry document, we of course pay for it. So there's no cost to the user if it's a document or a form that we have produced. If you get into a case and it's the other party, I mean, I think to be practical, I don't have the specific answer on this. I don't think we have a policy on this specifically. But I mean, whoever created the document should have an electronic copy. And generally, the electronic copies are what's most accessible or is used to make a Braille copy or a large print copy. So generally, you know, that electronic copy, whoever owns that should be providing it to the other side. And I think we've had some cases where judges have directed a party to provide it to the other side. So
let me just add in on this one. Number one, those watching in your offices, you may not know this, but you probably have all the technology you need to make documents accessible to most people with a print disability, blind, low vision, or dyslexic. If they need large print, you just print it on your printer with a larger font. If we need it for our computers to read, we need it in an accessible format like Microsoft Word or HTML, and then our computers can read it. Often our iDevices like an iPhone can read them out loud, and so on. If it's needed in Braille, there are services available that can print in Braille. Braille is used by a small number of people, and there are also devices that we could plug into a computer which will then present the electronic document, your Word document, in Braille on a raised screen that we can read without needing a printer. And there are always ways to see if you can get that kind of technology made available so you don't have to actually print a hard copy at all. But the fact is, and if you have a scanner and OCR software, which I think was largely developed initially to enable we blind folks to be able to read stuff, and now everybody else gets the benefit of it, that's all available in pretty much all of your offices, or was easy to get and costs very, very little.
Yes, I'm one of those judges who has directed court staff to convert it to an accessible format and have the court do it in two situations where the lawyers had visual issues, and I wanted to make sure they had the documents properly. So I had the court staff pay for it. A second question, Justice Malloy. If somebody has a disability that makes it difficult for them to comply with timelines for filing documents, is there anything that can be done to accommodate those persons?
In a civil case, you mean?
In a civil case.
Well, there's always scope in the rules for extending time, so that can be done. Again, it's a situation where it depends on the extent to which the rights of the other person have been affected. So difficult to give a categorical answer, but certainly the person's disability would be a factor to take into account in considering whether to extend the time.
I find that issue often comes up when they appear in court and they haven't filed an answer or a plan of care yet.
Yeah.
And what I'll do is we have duty counsel, we have advice counsel at the court. I'll direct that person, if they don't have their own lawyer yet, which is usually the case in that situation, to meet with duty counsel, advice counsel, and not to leave the building until they've actually completed the forms and direct them to that source. So that's one thing that you can do as well.
We don't have that on the civil side, though, is the
No.
problem.
Right.
Yeah.
Lori, how are ASL interpretation services arranged, and what is its availability?
I think
ASL is American Sign Language.
Yes, thank you.
American Sign Language. So in Ontario, we have English, American Sign Language, and also Langue des Signes Québécois for more French equivalent. And there are not very many French equivalent interpreters, especially in the north. It's a very difficult situation. Sign language interpreters in many countries, there's a shortage. It's certainly a worldwide problem. And I think we also have a cadre who are aging themselves, and I've heard of a number who've had injuries that have made them stop signing. So that's another issue going forward. The ministry did recognize that we were having some concerns over the last few years about sign language interpretation. So there is a project going on to look into the issue, and they've done consultations with interpreters and interpreter organizations, as well as the disability community, Canadian Hearing Society. So they're working on this. I'm not sure there's going to be a quick, easy solution. It may be other countries have looked at longer-term plans to try to increase that. And it's certainly not only the courts, other areas of the OPS, but also now that law firms are needing them and all these service providers across Ontario are needing interpreters, there's going to be more of a pull on the existing resources. One thing that has come along is remote interpreting. So certainly with teleconference equipment or other types of equipment, the interpreter doesn't always need to go to the place. So for our counter services, you probably could use remote interpreting.
Well, let me just explain what that means. The interpreter is somewhere else. They're on a video conference, which you could do with an iOS device.
Right.
And they're watching the deaf person signing, and then they can speak aloud what it is that they were saying, and so they can be off-site. So they don't have to travel to the venue where they're interpreting. And that, in turn, means that you can get more hours of direct interpretation from an interpreter without them having to spend their whole day in the car.
Right. But there's also, some interpreters do find the court very adversarial, and so attracting interpreters is, it's going to be a challenge for the ministry to continue that. And but we are looking at all these issues together, and we are trying to work with the disability community to see what can be done. I do think there's going to be some more training around courts and the legal system so that there's more available to interpreters who may want to come in and work in the courts. But we should have that report by next March. So.
Okay, Justice Bornstein, can a layperson, for example, a friend or a family member, testify as to the nature of the disability of an accused, or is an expert required?
Well, thanks for the warning on that question. It depends what the relevance of it is. Is it to a request for an accommodation? I think if it's a request for an accommodation,
yes.
Just off the top of my head, I would think that would be fine. If there's some relevance to the case, then I think you need a properly qualified expert, although that could be, it doesn't have to be somebody who is obviously a doctor or has training, but it would depend on the relevance of the matter.
I can't hear you.
You cannot hear me? Basically, it would depend on the relevance of the request. If it's a request for an accommodation, I would think, for the most part, that a family friend or a family member would be a suitable witness with respect to that. If a properly qualified expert witness was required for a matter relevant to the trial proper, then it would depend upon whether the family member, the friend, was a properly qualified expert in the Mohan test. So it would depend on the specific relevance of the request.
Okay. David, does the requirement to enhance access to the courts extend to administrative tribunals?
I would say sure. I mean, the charter applies to tribunals and who administer law, and Section 15 of the charter guarantees the equal protection and the equal benefit of the law without discrimination because of disability. So it would apply to all of them. The difficulty administratively is that if it's a challenge to get all of these services dealt with in the courts where there's no one public official in charge of every level of administration of the courts, the same is so where each tribunal is its own operation. And but nevertheless, each tribunal has some kind of staff, and it's still worthwhile to follow the same steps we've talked about here which is if you've got an accommodation need, let the tribunal know as far in advance of the hearing as you can. I know the Human Rights Tribunal of Ontario has developed a policy in this area. I don't know how many other tribunals are following it, but at least it's worth knowing that the sooner you ask the tribunal, the same idea goes as what we've been reiterating here for courts.
There's a practical question here. How do you serve a document on a person with a mental disability to prove proper service? There's I know in the family law rules, it's Rule 6 sub 3, that you have to serve it on the person, and if they have a guardian of property, you have to serve it on that person. If there's not a guardian of property, it's served on the public guardian and trustee as well, and that forms special service. Is there something similar in the civil rules, Justice Malloy?
Yeah, there would have to be if the person is not competent,
Yes,
not
if they're
capable,
not
then there
mentally
has to be an
competent.
appointment of a litigation. What's it called now? I'm betraying my age.
Public
Next
guardian
friend.
and trustee.
Yeah.
would usually
But
be
you can
that.
have a next friend just for the purpose of the litigation.
Yes.
You can do that as well. Or likewise with the public guardian. Can I ask if you would ask me that long question there about the commercial court?
I will. Here we go. Well, this was more a comment, and so I'm going to pass on the comment, and you can comment on the comment.
That
Here we
would
go.
be good.
Here it says, it's from Sleepless in Seattle. It says, I would like to share my experience as an associate lawyer working on a motion which lasted for several weeks on the commercial list. There were several senior partners from at least 3 law firms in the room, as well as a very well-respected and known judge. One of the lawyers was hearing impaired, though he had not told anyone about this other than myself. I am hearing impaired and wear hearing aids. For the most part, I am able to get by, but where acoustics are poor, such as in the courtroom, I have trouble hearing. I asked to have microphones put into the courtroom in advance. They were placed in the courtroom. Once proceedings started, one of the senior partners did not like having the microphones in the courtroom as he found it distracting. He voiced his displeasure and the microphones were turned off. No objections. I wanted to share this experience to illustrate some of the difficulties of enhancing access. Justice Malloy?
Yes. There's two key things. The conclusion at the end is that this illustrates a difficulty of enhancing access, or some language like that. That's not what I see as the difficulty here. The difficulty here is that one of the persons with the hearing disability didn't tell anybody about it. And at the time that the senior partner said, this is irritating, turn it off, there were no objections. So the people who need the accommodation cannot complain after the fact that it wasn't provided when they didn't speak up at the time. Turning off a microphone system that nobody feels is necessary is not a failure to accommodate if the judge involved had no idea that that was why it was there.
Okay, Justice Bornstein. Are you aware of any precedents for adjusting time schedules to allow counsel or litigants to appear in trials or hearings for part days? This would allow those with invisible, fatiguing illnesses to participate.
Am I aware of any legal precedents?
That's the question.
Well, I think, first of all, you have the jurisdiction as the judge supervising the proceedings in the courtroom to do that. I know in the Ontario court, when it comes to the criminal rules, there's also specific rules that permit judges to do that. Also, there's statutory rules in the criminal code, for example, if it's a preliminary hearing, to regulate the course of the inquiry. So I don't think there is any impediment at all, but rules, common law authority to manage your proceedings as well.
Can I just chip in on that one? I spoke to somebody yesterday, one of my colleagues, who had a criminal trial. The accused was on dialysis, and they sat every second day, and on the other days he had dialysis. At the end of the trial, she convicted him and made sure that the prison to which he was sent had dialysis. That's what they did.
Yeah, I think the message here is that if you give us enough advance notice, we can get very creative with our scheduling to get the best possible trial. Okay.
If I can just add to this, this is extrapolating it slightly beyond the topic, but even with child witnesses, for example, everybody wants the best evidence, and I know with my children when they were young, they would never be able to last till 1 o'clock before lunch. And so when I have young witnesses, I usually try to break for lunch at 11:30 or 12, just so that they're not completely burnt out.
And we can accommodate witnesses in a particular order as well, so that, perhaps we'll call them slightly out of order to accommodate them. We do that with witnesses all the time. Bring it up, come up with creative solutions, and we're willing to listen to them. Okay, so Justice Bornstein, are lawyers considered to be members of the public? I was told that the accessibility rules only apply to members of the public and do not extend to lawyers. Some of the accessibility issues are now moot, as we're going to have a new courthouse. I would still like your opinion.
Well, I don't know of any definition that would somehow exclude lawyers as members of the public, so all jokes aside. What about you, David?
I can't imagine.
We do accommodate lawyers.
I can't imagine. I can't imagine. I think we have time for one more question, then I'll do a quick wrap-up.
Okay, Justice Mcavoy, if a motion is brought, what are the remedies and how far can judges go? I don't know if that's a specific enough question, but...
A motion to accommodate a disability?
A motion to accommodate.
There's no limit on it. We can adjourn the trial. We can stay the trial in some cases. I've even done that. I've even stayed criminal charges in some cases where the person is just not capable anymore of going through a trial because of a disability. And it can be a tiny thing or it can be a very large thing. It really just depends on the circumstances.
Now, do you ever hear these, another question here which relates to that, do you ever hear these in chambers or do you always hear these in open court?
I'm not keen on doing things in chambers. If it's an administrative type of accommodation, that usually is done with the accessibility coordinator. They may come and talk to me about whether or not we can do X or Y, but, I don't like doing things in chambers. I prefer it in the courtroom.
Most things would be done on the record, but if both counsel were to come in and talk about somebody requiring more frequent breaks, that I'd be fine dealing with that in chambers. Just before we move over to David to wrap up, in terms of the question about the limits of the creativity with respect to accommodating, you really have amazing resources here, as you've seen. Just listening to Lori and Jeanette, why wouldn't you take advantage of that? And although David's going to be probably not taking any credit for having put this on, he's an enormous resource. We see that at every one of our Ontario Courts accessibility committee meetings. He's given his email address. He probably has more practical experience than anyone and is always willing to share it. So why not take advantage of those resources in terms of coming up with creative solutions to whatever difficulties or challenges that present themselves.
I want to thank you for that, Justice Bornstein, and thank you all for your presentations. Let me take 4 minutes to wrap up. And I want to say this. The law here is really easy. The Human Rights Code and the Charter of Rights each say that there's a duty to accommodate the needs of people with disabilities in accessing important services like courts. And that duty goes all the way to the point of undue hardship on the organization that's providing the service, meaning the courts. And the measure there isn't the budget of a particular courthouse or the budget of a particular office, it's the Crown, and there's lots that can be done. I think it's actually commendable that the Ministry of the Attorney General is working on a number of these fronts, but it's also really important for everyone watching this program to walk away with several end messages. Number one is, I'm a lawyer. It's on me to find out from my clients and witnesses, to find out early. I should put that on my checklists for early interviews, for trial preparation, for pretrial preparation. I should let the court know as soon as I can, which means I should find out as soon as I can. That in turn means that if I'm working in a law firm, I should go to my partners and my associates, and we should have a discussion about how we prepare cases for litigation to make sure that we're doing that across the board, so that others can learn from today's events. Another message I hope you'll take away from this is to check out the resources we've provided on the materials link, including learning about the guide that's available online for what you might need to do to comply with the various accessibility standards that have been enacted. You may have filing obligations this year under the customer service standard. You will have website obligations to look at. The other thing to know is that the duty to accommodate, as I said earlier, under the Charter, if you're government, and under the Human Rights Code, even if you're not, or if you are government, it supersedes all of this, so that even if the government's accessibility standards say you only have to have your website accessible X number of years from now, the Human Rights Code can impose obligations that are stricter and sooner. So your best bet is to talk to your web designer, talk to your colleagues about taking steps now to make sure that everybody could read your website. Why not? Why wouldn't that be good for your firm? And finally, we encourage you to use the resources that you've heard about today. Ask your access coordinators, tell your colleagues about them, so that if they are able to help you, that's great, and if they run into difficulties, let them know, let the ministry know, and let us at the Courts Accessibility Committee know, so we can try to find longer-term ways to move things along more quickly. And last but not least, again, a huge thank you to the Law Society. If this is being recorded for quality assurance, I want to name Paul Woolston and Andrea Bozajak, who did fabulous staff support for us. I hope you're blushing. And the Law Society is discussing with us having follow-up programs, a part 2 of this presentation, as well as archiving this for future use. I encourage you to encourage your colleagues, if they didn't see it today, to watch for a rerun. And please email us topics you'd like to see covered in a second program so we could focus on that. Thank you all for taking the time this afternoon to take part, and have a great rest of the afternoon.